I want to take this across to the lawyers who are concerned with this case. Advocate Shobha Gupta is Bilkis Bano's lawyer who is joining us. And Rishi Malhotra is also the lawyer of the convicts in this case. Shobhaji, the court also raised a question today, and it's a technical question. Is remission a problem? You have argued that this remission is bad in law. But it is also a reality that this remission is something that is allowed as per policy, and the court itself had said that it can be considered under 1992 policy. So I want to understand from you, how will you be arguing this case further to prove that this remission has been bad in law?
Today I have not argued. These are not my petitions which were listed or taken up on the board. These were two public interest litigations. We call them PILs.
Right.
Those petitions were filed. Those were, initial observations came from the court where the court was saying, so what was so wrong about? Basically, I believe they are saying what was so wrong about our order of 13th of May. And that we had simply asked for, and this is what Justice Rastogi said precisely, and Justice Vikramnath caveated. So to say that we had only asked the government to look into the application and consider the application, which is rightly so one can ask for. Yes, I wish the papers were there before the court and court were knowing in which order they are passing this order. But assume, irrespective of the facts of the case, the court would have decided to ask the government to please consider, because of your policy, they are entitled to make an application and you are duty bound to look into the application. So far, so good. Nobody is coming in the way of a remission policy, which allows and which is criminal law, criminal procedure code allows.
Right.
That you can ask for remissions. The government should have remission policies and the government should look into, and if they find the person is entitled for considerations, they should be allowed to come out prematurely. They can be allowed to. The major grievance, I'm not saying I'm giving up my challenge to the order of 13th of May passed by Supreme Court. Not at all.
Okay.
But if we have to today talk on the face of that order and the direction passed they are in, our precise objection to the remission order is, given the facts of this case, given the egregious nature of the crime committed in this case, which is not merely an allegation but established in 3 courts.
Right.
When Supreme Court was dismissing the special petitions filed by the accused, they made an observation that you have been let go very easily. And please do not force us to make more observations beyond this, but this is not a case to interfere. Normally, generally, when you come in appeal in Supreme Court challenging conviction, they do sit and consider the matter to see whether some mistake may not have committed. Every accused has a right to go for an appeal. Here in this case, on the first date, the special petitions were dismissed. That's not something so normal. And 2, on face of the fact that this nature of crime, why do I keep repeating? Like we all know now the facts of the case when it comes to what was the crime.
Yes.
But does it lie in somebody's mouth to say, no, that was not crime enough, or that was not one of the rarest of the rare case? Then if not death, but this death penalty was not granted in this one, or not sentenced in this case, that was already, a clemency shown to them for whatever good or bad reason. But a case of this nature, crime of this nature, can you as competent authority allow the accused and convicts of this crime come early out on road to live like another citizen? Is it punishment enough? For me, remission is not only were they entitled for remission. The fact that was this punishment enough for the crime they had committed? 14 lives they had taken.
Okay, so you are saying that essentially this is not a matter of whether they were entitled to remission, whether even under 1992 policy they can apply for that remission. But the state government or the panel that decided on it should have shown greater or better judgment before they allowed the remission. In legal terms, you are not making an objection. Am I right?
I'm so sorry. I'm so sorry. You got me wrong.
Okay.
I am not for a moment saying we are not raising that challenge.
Okay.
When you argue, when you buttress one argument, that doesn't mean you have given up the rest.
So, ma'am, how are you saying that this is bad in law? That's what I wanted to understand from you. What will your challenge be?
My friend, today none of us have the remission order in hand. Okay. Now, remission order, when it is there, we can examine the circumstances which have prevailed over the authorities to come to a decision. Yes, for us, it is a befitting case where, despite the crime committed by them, despite the nature of the crime, despite the number of lives they have taken, the number of rapes they have committed, on each person, multiple rapes by multiple people. A 3-year-old child was smashed to death. If these case, after considering, one can say, oh yes, still it is a case for remission,
then it's a problem.
We have to see that whether that was the case. Yeah. Today we are saying, how come remission? Today we do not have the order.
Right.
So we cannot say the reasons given were not correct. We are saying, how come even on facts of these cases a remission come?
Okay, fair enough. Fair enough. I do want to point out to our viewers that the other problem in this case is that it was decided under 1992 remission policy, which does not have any exceptions or barring. The new remission policy in 2014 had exceptions that in heinous cases of rape and murder and gang rapes, those remission cases must not be considered, and it is also a stricter remission case policy where it has to go case by case. You have to go to the judge also of the judge who presided over the case and convicted the accused. Rishi Malhotra, I'm coming to you now. You've heard what Bilkis Bano's lawyer Shobha Gupta is saying. The problem is that it has just set everybody's, alarm bells ringing. You look at the nature of the crime and everybody's alarmed. Is 15 years enough for this? How can you get early remission in a case like this?
You see, incidentally, I will begin with, I've been hearing Shobha for last 3 or 4 days now. And I really want to ask one question to Shobha, that how do you define a time limit in a case of life sentence? Will you be happy that if they would have been released after 20 years or 25 years? Or you would have been happy that they would not have been released at all? So you are nobody to define that 15 years was less. 15 years was less for a period to be considered for premature release. You are nobody. It is the code of criminal procedure which is applicable, and it is the jail policy, it is the remission policy which is applicable to determine the period of release. So nobody can fix a timeline that it should have been 20 years, 25 years, maybe 50 years, that nobody ought to have been released. Secondly, I don't understand that the principle of law has to be applied vis-a-vis an emotional plea. The law says that for the conviction time which has been awarded by trial court, the policy which is existing at that time, that has to be applied. And that's what precisely the Supreme Court has held in May 22 judgment. Now, if my friend wants to challenge the Supreme Court judgment of 13th of May 2022, the remedy lies is very much only a review petition. There cannot be a writ petition challenging a Supreme Court judgment. This is not permissible as per a 5 judges bench decision in Rupa Ashok Hura. My friend knows about this thing also. So therefore, today, Mr. Kapil Sibal made a statement even day before the Supreme Court when he was mentioning this matter, saying that we are not at all challenging the Supreme Court judgment because he knows the remedy lies elsewhere. So, and also today, he confined his argument only to the plea that what he just wished to see is was there any application of mind by the remission board. So, and this was apropos when Justice Rastogi asked him a simple question that remissions are granted day in, day out. So, what's unique in this case that remission has been granted?
In this case, Mr. Malhotra, repeatedly people are saying what is unique is the nature and the gravity of the crime. We don't see such cases day in, day out. So certainly in such cases, we need to act stricter.
They have acted stricter, they have been punished, they have served out the entire sentence of life imprisonment. And what do you want then? They have not been awarded death sentence by either of the courts. So there has to be some timeline. Someday they have to come out. And when have they come out? Now lots of you cry that why have they come out?
Okay.
And it's a
Can Shobhaji respond to your question? If 15 years is not enough, then would 20 or 25 be enough, ma'am?
I am nobody to actually decide, but the fact remains. This is, I'm wondering, has Rishi actually read the judgment of the trial court and the High Court? He has, Rishi, let me just complete. He has not placed those judgments in the writ file. He is saying how come a writ is maintainable. His writ was how come that maintainable, because that was again a judicial order. And the 9 judges bench is very clear in Naresh Mirajkar that no writ petition would be maintainable for that reason. Here in this case, it's not my discretion whether 15 years is enough or not. The court, if you read judgment, Rishi, of the trial court, it is a categorical discussion about what sentence. Why not death penalty and why life? Please go and read the judgment. If you pay some heed to the judgment, your question is answered there only. Now the court there says, and if you please see unamended section 376 2E and G, it says life imprisonment, that is till last day of your life.
Okay, can you respond,
If
Rishi
the
Malhotra?
section, no, let me complete.
Okay,
If
okay.
the section
Of
so
course,
clearly
of course.
says so, then how come, and the punishment granted is life imprisonment? So the court who was considering this matter, who have seen all the evidence, said this is a case fit for life imprisonment. So please do not misguide yourself when you say that they have undergone the complete sentence. If they had undergone the complete sentence, then where was the occasion for them to going and asking for remission?
Right. Okay, let him respond now, ma'am. Rishi.
No, I am surprised because I thought Shobha is aware of this thing, or she is deliberately trying to be unaware. But right
I
from
don't know all that.
Supreme Court judgment from Maru Rams, that is a 5 judges bench decision, which say that normally life means till the end of natural life. There is no dispute on that. But then there is a caveat to that, which says that life imprisonment would be always be subjected to the power of granting remission as provided in the section 432 and 433. Then there was an amendment in Code of Criminal Procedure which bring in 433 capital A, which says that of course life can be curtailed by the power of remission, but the minimum requirement is actual 14 years. So I really wonder that man has undergone 15 and a half actual sentence. He has been released. Nobody has power to frame a timeline that he should have been released after 20 years or 25 years. The law has been applied in correct perspective. Concurrence of central government is taken under section 435. What is the big deal? And that's what Justice Rastogi had asked Kapil Sibal today also, that remissions are granted day in, day out. So what's the big deal in this case?
Okay.
So therefore,
I have time
as a
for final
concession, a
questions.
statement has been made that we just want to see application of mind, that's all.
Yeah.
Let
And
me
just
come
one
in
more
for
thing.
Yes.
A speculative writ petition has been filed in Supreme Court without challenging the remission order, without seeing the order, and they said that order is bad in law. Now, how come this is possible?
Okay.
You don't know the order of the remission board, and yet you file a PL saying that it might be wrong. So therefore, please consider and please call for the remission order, and then we will decide.
Yes, Shobhaji, very quickly, I have final questions for both of you. Shobhaji, very quickly, please.
And I just come in for that, what Rishi was saying.
Yes.
Is speculative writ petition. That's okay, we'll deal with that in court, like they would deal with in the court when they are saying that. But Rishi says they have applied law correctly. When none of us have the order of remission, Rishi, how do you know they have applied law correctly? That's the whole question. Have they applied law correctly? Can, in the facts of these cases,
therefore,
on the face of the nature of crime,
this petition is premature.
after applying the mandatory factors of the constitutional bench in Shraddhanand case, reiterated in Sriharan, could anybody grant remission after 14 years to accused or convicts of that crime? That's the whole issue, and no point of defending, because even you have not seen the order. None of us have seen the order, so you can't, it doesn't lie on your mouth to say, no, they have applied it correctly. Let's wait for the order to come out for all of us.
Okay, Rishiji, 20 seconds. Then I fire my final questions to both of you, please.
Yeah, I completely agree with Shobha. It lies nowhere in nobody's mouth. So therefore, this PIL was totally premature and speculative. That's why I'm saying so.
Okay.
No order, and yet the matter has been filed in Supreme Court.
Can I fire my final questions to both of you? Shobhaji, a lot of politics has also come into this case. Do you feel that that is helping the case, or that is actually taking the, distracting away from the case?
See, I am not into that political question at all. I am only dehost politics, whosoever. See, every individual is individual. Na? He can belong to any profession, any occupation. Can we take away the sensitivity of the case and their concern about the outcome as citizen of this country simply because they belong to political party A or they belong to a particular occupation? I am refusing to take that we have to doubt somebody's intention and credentials simply because they belong to a particular occupation.
The reason I ask you this is because the question has been raised that there were BJP members in the panel and therefore there must be something dicey or shady or biased in this decision. That's why I ask you this.
I have personally not even once, for last 4 days I am talking to everyone, not even once touched this issue.
Okay.
I personally believe a wrong is wrong, irrespective of the caste, community, occupation, mindset, whatever.
Okay.
That's why I'm not even responding to that particular observation made by one of the committee members.
Sure enough. Rishi ji,
their occupation and loyalties or connections or whatever they are coming from. Fact remains, is this a case where collectively 10 persons consensus or can pass a consensus? Not 1 out of 10 said, sorry, I am not agreeing with this order. Not one. We have to see the order.
Okay.
And today, even Rishi, I would tell you one thing, in all fairness, when you say this about this petition, I'm more than sure on the facts. Even you are counsel for the convicts, you have all the reason to defend whatever you have presented before the court and the order passed in their favor. None of us have read the order. If few people who are, aggrieved by the order as citizens of the country and have come to the court with all right intentions, saying premature, no, everybody is waiting for the order and order would be attached with the file.
Okay, ma'am. Let me give him the final minute. I'm running out of time. Rishi Malhotra, the other problem also is, apart from the political question, the other problem also is these convicts were welcomed in a very, in a fashion that upset a lot of people. It left a bad taste in their mouth. It may not be a legal argument, but people are aghast.
You see, to this I would only answer that a person has a right to rejoice after serving 15 years. So please don't mix morality with legality. And about legality, I must say that law also says categorically the strangers to a criminal prosecution has no right whatsoever to challenge any action. So these political parties who have filed this frivolous PIL, these are all strangers to a criminal prosecution, and the court doesn't permit this. There's a catena of judgments which will cite now in Supreme Court, because this was also very strange. An action is sought against us and we are not made parties to this writ petition. It was my intervention today. They allowed us to be impleaded, and now we have a chance to file our reply before the Supreme Court.
I have to leave it at that. I do thank both of you for joining us. We'll see how this goes.